Hi students, today we're going to revisit Riggs et al. Versus Palmer and take a closer look at some of the arguments made by the judges in that case. Before we do that, I want to just remind you of the sort of central philosophical question that we're looking at here. And that question is a question about what the law depends on, what the law is constrained by. So there are a few options that we mentioned last time. You might think that the law just depends on the literal or straightforward reading of the relevant statutes. That's one possibility. Maybe the law is constrained by the intent of the legislature, or depends on that. Maybe you think that the law depends on the fundamental maxims of the common law. It's constrained by those sorts of things. Maybe you think it's constrained by the truths of morality. So, generally speaking, I think that maybe the first couple options, one, maybe two, maybe those are sort of like legal positivist style interpretations where we don't have to know anything really about morality in order to know what the law says. Whereas once we start getting into the third and fourth options, then it looks like there is some sort of moral basis underlying what the law says. So we're going to take a look at sort of the kinds of arguments that the different judges make and see what direction those point in. So to begin, we're going to look at the majority opinion written by Judge Earl. That again is the opinion that comes first. And we're going to start, I'm going to reconstruct some of these arguments. We're going to start sort of with the conclusion down here at the bottom. So Judge Earl, he starts by considering an argument that the opposition is going to make. So here this argument, C2, is a conclusion that his opponent thinks is right. So the conclusion is that Elmer is entitled to inherit from his grandfather. And then what we want to do is figure out like how the opponent gets there. So this argument, it appears on page 184 of the text, and it goes like this. The testator is dead, like Francis is dead. His will was made properly. It's been admitted to probate. So sort of the rules have been followed. From that, if that's true, the sort of intermediate conclusion, right, the intermediate conclusion that we're trying to get at is that the will has effect according to the letter of the law. So we look at the letter of the law, it has effect according to the letter. And so if the will, the testator is dead, and they've gone through all the right processes, then the will has effect according to the law. So the will has effect according to the law. And if that's true, if the testator's will has effect according to the law, then Elmer's entitled to inherit, because that's what the will says. So what we've done is we've reconstructed in a valid form the kind of argument that the opposing view is going to make. Now, why is this important? Why put arguments into this form? And the reason to do that is that once we have this, we can sort of go through premise by premise and figure out which of these premises is the problem. What's the thing that the two sides disagree about? So when we look at this argument, for example, we've got it in a valid form. That means if the premises are true, the conclusion has to be true. But the majority opinion, Earl's opinion, right, thinks that this conclusion is false. So what is Earl going to deny? Is he going to deny premise 1, that the testator is dead, that his will was made in due form, and that it's been admitted to probate? No. He's going to grant all of that. I think what he's going to deny is premise 2. Just because those things are true doesn't mean the testator's will has effect according to the letter of the law. So there's something about the inference from premise 1 to C1 that's a problem. And what's the inference? Well, it's explicitly in premise 2. If premise 1 is true, then the testator's will has effect according to the law. And Earl's going to want to reject that claim. Now, after he sort of gives an opposing argument. He's going to give his own argument. And I think he makes two different legal arguments. This first legal argument we get on pages 184 to 185. The conclusion, remember, is the opposite of the opposing argument. So he's going to say Elmer is not entitled to inherit from his grandfather. Why is that? The first reason he gives is this, that the law's content depends on the intentions of its makers. So the content of the law depends on the intentions of the lawmakers. So how do we get from there to C1? There's this intermediate premise. Lawmakers didn't intend for the law to allow murderers to inherit from their victims. So law's content depends on the intentions. Then we say something about the intentions. The lawmakers didn't intend for the law to allow murderers to inherit their victims. And we see, well, how do we, what form do we use to get to that conclusion that we've got there at the bottom? And one thing we can always do, this isn't a form that we've talked about before, but it's maybe just a slightly more complex version of a form that we've talked about before. We can always just combine two independent claims and say if those two claims are true, then this further thing is true. And I think in this case, that premise 3 is actually pretty plausible. If the content of the law depends on the intention of the makers, and in this case the lawmakers didn't intend for the law to allow murderers to inherit from their victims, then presumably Elmer is not entitled to inherit from his grandfather. That sounds right. So premise 3, the argument's valid. Premise 3 actually seems pretty plausible. So if somebody's going to object to this argument, what are they going to object to? Are they going to object to premise 1, that the content depends on the intentions? Or are they going to object to premise 2, that the lawmakers did not intend for the law to allow murderers to inherit from their victims? And I think premise 2 sounds right. Lawmakers probably didn't plan on or want someone like Elmer to inherit from Francis. So I think the questionable premise, right, the controversial one, is premise 1, that the content of the law depends on the intentions of the lawmakers. We're going to see later on in the course Antonin Scalia, Justice Antonin Scalia, sort of be very critical of this idea that the content of the law would depend on the intention of the lawmakers. So anyway, this is the first argument. I'm not sure that it's the best argument, but that's one reason why Judge Earl thinks that Elmer's not entitled to inherit. Argument number 2, again, same conclusion, Elmer's not entitled to inherit from his grandfather. How do we get there? Premise 1, all laws and contracts are controlled by fundamental maxims of the common law. Okay, that's premise 1. So we've got maxims, we've got precedent, we've got to look at that. How the law and how contracts work depends on those maxims. If that's true, premise 2 says, then people aren't entitled to profit from their own crimes. Why would that be? Well, I think it's because one of the fundamental maxims of the common law is that no one can profit from their own crimes. I'm gonna give you an argument for that claim in a minute here, but for now, we'll sort of set that argument aside, and we're just looking at the structure, right? Premise 1, all laws and contracts controlled by fundamental maxims of the common law. Premise 2 says, if that's right, people aren't entitled to profit from their own crimes. Conclusion, no one's entitled to profit from their own crimes. And if people aren't entitled to profit from their own crimes, then Elmer can't profit from his crime. So Elmer is not entitled to inherit from his grandfather. That seems right. So again, the argument's valid. A, if A, then B. So B, if B, then C. So C. That structure's valid. So if there's a problem with this argument, it's got to be a problem with the truth of the premises. I think premise 3 looks good. the controversial part of the argument is going to be premise 1 or premise 2. Are laws and contracts controlled by the fundamental maxim of the common law? I think that's actually like generally well accepted. I think that maybe the more controversial thing is premise 2, which is if all laws and contracts are controlled by the fundamental maxims, then no one's entitled to profit from their own crime. And I think the question might be, is that idea that no one's entitled to profit from their own crime, is that really a maxim of the common law? And so in support of that idea, to sort of defend premise 2, Judge Earl gives a kind of sub-argument. And that's sub-arguments for the claim that the principle that no one's permitted to profit from their own crimes is a maxim of the common law. That's the conclusion. Why should we think that that's true? According to Earl, that's because we have this precedent, we have this case that the judges have ruled on before, Insurance Company versus Armstrong. He says, in that case, we look at how the Supreme Court ruled. And they ruled that one forfeits one's right to collect on an insurance claim if you murder the person who was insured. So I think this was a case where maybe a woman, there was like an insurance policy on her husband's life, or life insurance policy, and then she murdered her husband, and she said like, okay, I'll take my money now. And the Supreme Court said, not so fast, that's not going to happen. And the thought here is that if in that case the Supreme Court ruled in that way, then there must be this underlying principle that you can't profit from your own crime, right? So that case is kind of like this one, right? There was no law that said you can't collect an insurance claim if you murder the person who you have the claim on. No, there's no law like that. Rather, the Supreme Court was just sort of, it was appealing to a kind of principle that it thought was there. And so what the judges in this case were saying, well, if the Supreme Court did it, right, if the Supreme Court appealed to that principle, then we should appeal to that principle too. Then that principle is there, it's in the law. So that's sort of to support that second argument. Now those two arguments are kind of like legal arguments. They're sort of saying like, here's how the law works. But I think Judge Earl also is going to give some moral arguments, right? They're arguments that don't really depend on, exactly what the law says or how the law works, just independent arguments for the conclusion that they're arriving at. One they give explicitly. There's sort of two others that I think are kind of in the background that Judge Earl doesn't say explicitly, but that he could say if he wanted to. So let's look at those. The first one that Judge Earl does seem to mention is, again, it's trying to get us to the conclusion that Elmer is not entitled to inherit. And the main premise here is that it would be immoral to allow a murderer to profit from his crimes. So again, this doesn't say anything about this is a fundamental principle within the law. It's rather just saying like, it's positively immoral. It would be wrong to let this guy profit from his crimes. And if that's true, then Elmer shouldn't inherit his grandfather. So if it's immoral to allow murderers to profit from their crimes, then Elmer shouldn't inherit from his grandfather. That sounds right. So Elmer shouldn't inherit from his grandfather. If Elmer shouldn't inherit from his grandfather, then he's not entitled to inherit. So this is the sort of natural law style premise. If someone, if something shouldn't happen, if we should rule in a certain way, if the moral thing to do is X, then it's the legal thing to do. Then Elmer's not entitled to inherit. That looks like the sort of premise that a natural law theorist is going to endorse. And that premise is probably going to be one that's controversial. Another moral argument starts from the claim that if someone is entitled to inherit from another person, then it must be the case that the other person would have wanted that person to inherit his or her things. So the idea here is that what wills are supposed to do is they're just supposed to distribute money in accordance with the person's wishes. And so we can just ask ourselves, what would Francis have wanted? And the thought here is Francis wouldn't have wanted Elmer to inherit his things, and the conclusion is that so Elmer is not entitled to inherit the person's things. Again, maybe I've oversimplified here a little bit. Maybe I should make it a two-part argument that has as one premise like if someone shouldn't inherit something, then they're not entitled to. Maybe I've sort of oversimplified here, but I think this gives you the idea, right? That we just think about morality, the morality of the situation. When we look at the morality, we see that Elmer shouldn't be inheriting. Why not? Because Francis wouldn't have wanted him to, had he known that he was killed by Elmer. Okay, finally, moral argument 3. Allowing Elmer to inherit would have bad consequences, right? Here's the main one. People would go around murdering their grandparents or their parents so they could get the money. That would be a really bad consequence. Now, presumably, the law would get amended and we'd fix this issue. So maybe this really wouldn't have quite so bad of consequences, but we should certainly be worried about this. If the legislature has its act together, then maybe we can avoid this, but maybe it's not worth the risk. So if we allow Elmer to inherit, that's going to have bad consequences, but the court shouldn't rule in ways that would have bad consequences. Again, that's a moral claim, so the court shouldn't allow Elmer to inherit. And again, maybe we could make this into a two-parter, right? If the court shouldn't allow Elmer to inherit, then he's not entitled to. Again, that would be sort of a natural law type premise that says if something shouldn't happen, then it's not legal. Okay, so those are the arguments for the majority side. Now let's look at the dissenting opinion, Judge Gray's. He also has a number of arguments that he's going to give. He's got a couple legal kind of arguments, a couple moral kinds of arguments. So, again, he's going to argue, if we look at the conclusion that's here, that Elmer is entitled to inherit. So why think that? One reason to think that is that the law's content depends on its language, not the intentions. So in the majority opinion, we saw the argument that the law's content depends on the intentions. Here we're getting a different premise that the law's content doesn't depend on the intentions, it depends on the language. What does the language say? The language allows people like Elmer to inherit. So if those two things are true, if the law's content depends on the language, and the language allows people like Elmer to inherit, then it seems like the law allows Elmer to inherit, or Elmer is entitled to inherit from the grandfather. So here, I think premise 1, right, is the controversial one. Does the law depend on the intentions? Does the law depend on the language? That's going to be a debate that we see again in the next sort of mini unit that we go into. The second legal argument that Gray makes, again, it's going to get us the same conclusion. The court may not deny Elmer the inheritance, or that Elmer is entitled to the inheritance. How do we get there? The premise of this argument, the first premise, the main premise, is that if the court denies Elmer the inheritance that Francis' will promised him, then it imposes an additional penalty on Elmer. So the idea here is that whenever you violate a law, like you commit murder, you get a punishment, thrown in jail for 30 years, let's say. But if the court takes the inheritance away from Elmer, then it's giving him an additional punishment. So the thought is something like, well, if they take away his inheritance, then if you do X, you commit murder, then you not only get thrown in jail for 30 years, but you also lose your inheritance. That seems like it's giving us an additional penalty, and there might be something illegal about that, right? So it might not be legal to over-punish or to punish someone more than this certain kind of sentence. And so what Gray's arguing here is that the court can't impose any additional penalties on Elmer, and so it can't deny him the inheritance because that would be a kind of additional penalty. I think, maybe the controversial premise here is premise number 2. If it denies Elmer the inheritance, in a way it imposes a penalty. I mean, can the court impose additional penalties? I think what's ambiguous here is maybe what we mean by an additional penalty. It is an additional penalty in one sense, in the sense that like he's missing out on this thing he would have gotten. It's not an additional penalty in this other sense, like maybe he wouldn't have gotten the inheritance if he had murdered his grandfather. So that's complicated. But the argument, I should say about all these arguments, they look like generally pretty good. There might be a flaw with the premise, but it's not obvious exactly what the flaw is. One thing to be sure, though, and I should emphasize this, is that if an argument that says Elmer is entitled to the inheritance, if an argument that says that is sound, then the arguments that say Elmer is not entitled to the inheritance, those can't be sound. So either Elmer is entitled to the inheritance, or should inherit, or he shouldn't. It can't be both things at one time. So when I'm giving you all these arguments, I'm not saying all these arguments are sound. They can't all be sound. But I'm just offering you some possible arguments that you might think are sound. And if you find one that you do think is sound, you think this is the best argument here, then if I was to ask you to make an argument for your position, you'd want to use that one, sort of explain why it's right. You'd also kind of want to be able to explain why opposing arguments that argued for the opposite view, explain what's wrong with those arguments. Okay, I think Gray also makes a couple more arguments. So, one more argument gets at this claim that the court shouldn't give Francis's property to Mrs. Riggs and Mrs. Palmer. And the reason for this is that the court should not give a testator's property to people whom, for all we know, the testator might not have chosen as its recipients. So the thought here is that, maybe Francis had a reason for not wanting Mrs. Riggs and Mrs. Palmer to have all his land or his property. That's why he gave it to Elmer. And so, if that's right, then we shouldn't find in favor of Riggs and Palmer. We shouldn't give them the land, because that wouldn't have been in accordance with Francis's will. Really, this argument preys on or depends on this sort of idea that, Francis's wishes are kind of unknown, and so maybe we can't divvy the will up in any way other than it sort of said, because we can't be certain that that's what Francis really would have wanted. So if premise 1 is true, if courts shouldn't give testator's property to people whom, for all we know, the testator might not have chosen as recipients, then it seems like the court shouldn't give Francis's property to Mrs. Riggs and Mrs. Palmer. I think that premise is true. The real questionable premise here, the controversial one, is premise 1. Maybe there are times when we were certain enough that the testator would be okay with this, so it's worth it. The final argument that we're going to look at is moral argument number 2 from Gray's opinion. And again, these arguments don't necessarily show up directly or obviously in the text. I'm just sort of recreating them. The way that I've put them isn't the only way to put them. You could put them slightly differently. The goal here, what I'm trying to show you, is just that the reasoning that these judges are going through does take a kind of logical structure, and that we can recreate that, and that when we recreate it, it can help us think through some of the arguments being made. It can help us see why we think someone's position is good or not so good. So, conclusion 2, Elmer should be permitted to inherit. How does the argument go? If nothing in the language of the law seems to prohibit X, then it would be unfair for judges to prohibit X. So nothing in the law says that you can do something, and it seems unfair for judges to prohibit that thing. Now, nothing in the law seems to prohibit Elmer from inheriting from the grandfather. Nowhere in the law do you see something that says, if you kill to inherit from someone, then you won't get that money. And so there's a way in which Elmer can just say, like, well, I murdered thinking that this is what I could do. The law didn't say anything against it, so I sort of expected that I could be able to get this money. And I was willing to go to prison for 30 years or whatever to get it. The conclusion from those first two premises is that it's unfair for judges to prohibit Elmer from inheriting. Right? They're prohibiting him from doing something that it seemed like he could do. And if it's unfair for judges to do this thing, then Elmer should be permitted to inherit. Conclusion, Elmer should be permitted to inherit. So that's another kind of moral argument. Again, it's not necessarily a legal argument, it's just sort of a moral argument. The law shouldn't sort of impose penalties that it didn't warn you about to begin with. So having looked at all these arguments, we want to think about what conclusions can we draw? What should we learn from this case, Riggs versus Palmer? Again, this case is sort of going to tell us a little bit about the debate between legal positivists and natural law theorists. So what can we learn? To start, it's just worth noting that this is a hard case. Right? On the one hand, a straightforward reading of the law seems to permit Elmer to receive the estate, and it seems unfair for the court to prohibit Elmer from doing something that the law seems to permit. That's sort of the last moral argument that I attributed to Gray. One sort of reason to think this that I haven't mentioned is that secret statutes are unjust. If a ruler made a bunch of rules and sort of hid them from the public, it would be unfair for the ruler to punish people in accordance with those secret statutes. There's something about the law needs to be public. We need to know about it. So prohibiting Elmer from receiving the estate, his grandfather's estate, seems to require that judges appeal to a kind of secret statute, something that Elmer couldn't have known about beforehand. On the other hand, it seems like Elmer doesn't deserve the estate, right? He killed Francis to get it, so he doesn't deserve it. There'd be all sorts of bad consequences with allowing people to profit from their own crimes. And so, for that reason, it seems like Elmer ought not to get it. So there do seem to be these two moral arguments for both sides that are pretty strong. Sort of the arguments go both ways. This case is also a significant one. So not only is it a hard case, but it's significant. Why is it significant? Well, it forces us to reflect on what we think judges should do when the law runs out, so to speak. What happens when the law just doesn't speak to the kind of situation that we've got here? One thing we notice is that when the law runs out, judges can't help but appeal to moral principles to justify their decisions. So really, a decision has to be made here. And to sort of solve that, the judges have to appeal to some sort of sense of morality or normativity, one that maybe isn't even there in the law, right? If that's correct, then it seems like maybe the natural law theorists are right, that the existence and authoritativeness or validity of law depends on moral facts or moral principles. So insofar as in these cases judges have to appeal to morality, then maybe there is something about law requiring a bit of morality, or morality being sort of built into the law. Ronald Dworkin, who we'll sort of learn about later, uses this case. This is one of sort of his favorite cases to try and show precisely that law is inevitably going to run out. And when it runs out, we need to appeal to moral principles that are built into the law. So he thinks that law is, morality is built into the law. So maybe we should be natural law theorists then, right? Maybe this is the best argument for natural law theory. I'm not sure about that. I don't want to say it's not true, but I don't want to say that it is true either. In Philosophy of Law, the Fundamentals, Mark Murphy argues, and I think this is maybe a position that a number of people kind of take, that we should really think of legal positivism as identifying the correct account of what it takes for a rule to be a law. So the positivists are right. A law, whether or not a law exists, is just a social phenomenon. How do people act? What do they do? What sorts of rules are they willing to act in accordance with? And that we should think of natural law theory as giving us an account of what it means for a rule to be a good law. So a good law is just. A good law promotes the common good. But something can be a law without actually doing that thing. So that's one way to think about what these two things are doing. Maybe they're just answering slightly different questions. The legal positivist is telling us what it takes to be a law. The natural law theorist is telling us what it takes to be a good law. As I see it, whether a rule is a law depends on whether that rule is authoritative. So whether or not something is really a law in the standard sense. Is that thing guiding people's behavior? I say whether a rule is authoritative is going to depend on whether it's capable of guiding behavior. And if we take that insight as true, then it seems like rules don't need to be just or moral in order to guide behavior. Right? If you just threaten people enough, then maybe they'll go along with it and they'll say that it's a rule. I also want to note that a rule's being just isn't sufficient to get people to follow it if those in charge don't have the power to enforce it. So again, maybe I'm going back to something like mask wearing. DeWine sort of said, Ohioans are going to have to wear masks if they're going to be shopping. And then he got a bunch of pushback and people saying like, no, we're not going to do this. This is unjust. It's unfair. It violates our liberties. And so even if that rule would have been a just law, if people aren't going to follow it and people in charge aren't willing to enforce it, right, then its being just isn't enough to make it authoritative. It's not really going to have the force that laws are supposed to have. So these things are sort of strikes against the natural law theory. Rules don't need to be just or moral to guide behavior, and being just isn't enough to make them guide behavior. But at the same time, there's strikes against legal positivism too, right? That someone in charge has the power to enforce a rule isn't sufficient to get people to follow it if they all think that it's unjust. So even if, right, DeWine says, well, I'm going to punish everyone who doesn't wear a mask out in public, just him saying that, and even if he enforces it, might not be enough to really give it the character of law, might not actually guide behavior unless people actually think that it's just, right? So we might think about protests or something, in response to the George Floyd killing, for example, where protesters are, rioting the streets or something. The police might say, like, we're going to put down this riot, or get off the streets, or go home, go to bed. If the protesters, even if that requirement is a just one, even if the law enforcement is trying to enforce those laws, if enough people think that the laws or the requirements are unjust, they're not going to obey them, even if the people in charge have the power to enforce them. So really, what a law is then is it something that guides behavior, and both natural law theory and positivism point us in that direction. Like, what does a law need? What does a rule need to have that authoritativeness? It needs to be enforceable. It needs to be the kind of thing that people are going to listen to, and that requires it to be just, and it requires it to be made by someone in power. And those two things, when they come together, both contribute to a rules being a law. So while both theories have their strengths, they also have their weaknesses. And I think maybe it's best to understand law, not as like, well, the positivists get it all right, the natural law theorists get it all right, but rather they're both sort of identifying something that the law really needs in order to do what it's supposed to be doing, which is guiding behavior. All right. So as we look forward, right, this debate between the legal positivists and the natural law theorists is pretty theoretical. Right? I realize that sort of the discussions that we've had about it might seem like in the clouds, they might seem like over your head or something like that. So in the next mini unit that we look at, we're going to look back at how our views on the nature of law, whether we're positivists or natural law theorists, how our views can affect our theory of judicial interpretation, and maybe vice versa, right? How our theory of judicial interpretation is going to affect our view about the nature of law. In particular, we're going to be looking at a debate between Antonin Scalia, a former U.S. Supreme Court Justice, and Ronald Dworkin, a former Harvard professor. In preparation for that, we're going to look at two more cases, Church of the Holy Trinity versus U.S. and Smith versus U.S. And both of those cases are sort of interesting and important in the way that kind of Riggs versus Palmer is important, because they sort of raise significant questions that need to be answered in order to sort out exactly how we're going to go about ruling in the tricky cases. All right, that's all for this time. See you next time.